Counsel, can I stop you a moment and back up a minute? You admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has provided that cause of action. You want to go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
So history proves a lot to me and to my colleagues generally. But there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists for state offices. And you're basically telling us that you want us to go 2 steps further. You want to, maybe 3. You want us to say that self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And so this is a complete preemption in a way that's very rare, isn't it?
Well, that's the only thing I would disagree.
It's rare under the 14th Amendment.
Oh, of course it's rare. This is a one-off situation. And, Your Honor, the only thing
it is one-off. I don't disagree with you. But it's not with respect to how we've defined self-executing.
We're not asking this court to redefine the concept of non-self-execution. We were careful in our brief not to rely on that phrase. And Griffin's
right,
case
you are, because it's not.
That's right. And
okay,
Griffin's
so
case.
Now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a precedential Supreme Court decision.
That's correct.
All right? It was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case, he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated, and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect. So you're relying on a non-presidential case by a justice who later takes back what he said.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
And it did away with it later.
It did away with it later. But
that has nothing to say with respect to what Section 3 means. Can we get to the issue, which is, I think, one that I go back to that I started with, and very briefly, what sense does it say that states can't enforce Section 3 against their own officials? Because I think logically those are 2 separate issues in my mind. Can states enforce the insurrection clause against their own office holders, or can they enforce it against federal officials, or can they enforce it against the president? Those are all 3 different questions in my mind.
And the answer to all 3 of those questions turns on whether this court agrees with the holding of Griffin's case. If Griffin's case is the proper enunciation of the law, then a state cannot do any of the things Your Honor suggested unless Congress gives it authority to do so.
So a non-presidential decision that relies on policy doesn't look at the language, doesn't look at the history, doesn't analyze anything than the disruption that such a suit would bring, you want us to credit as precedential?
Because Congress relied on Griffin's case when it enacted the Enforcement Act of 1870 and established